Good afternoon. Good to see many of you again. We're here for the last of the CLE series put on by the University of Tulsa. I want to thank the law school, and if you get a chance to see Dean Levitt, thank her if you can. This has been a great resource that the University of Tulsa puts on for the local bar. It's free CLE, free lunch. You get to come back up and see what's going on at the law school and get involved a little bit. And I know I've seen several of your faces at the past CLEs, so if you get an opportunity to say thank you, please do so. It's a great program. I'm really pleased that the law school offers it. Before I get off and introduce our speaker, I want to remind you that the Law Review Symposium is coming up, and Aaron Barak from Israel is going to be speaking. I'm sure you've received an email on that. It's quite an honor to have him come to our law school and speak, and I'd like you to come out and see that. I think it is Friday, March 25th is the symposium from 8 a.m. to 5 p.m. Put that on your calendar. This afternoon, we're fortunate to hear from David Tracy. David has practiced law in Tulsa for over 25 years. He's a partner in the Naylor, Williams, and Tracy law firm. His practice is focused on family law, including litigation and appeals, mediation, and collaborative family law. He promised he would tell me what collaborative law means in the speech that I had to stick around to hear. He's a qualified family law mediator in the Oklahoma District Court, under the Oklahoma District Court Mediation Act. He's affiliated with the Tulsa County Bar. He was family law section chair in 94-95, the Oklahoma Bar Association, and is also a member of the Oklahoma Academy of Collaborative Professionals and International Academy of Collaborative Professionals. He's involved extensively in the collaborative field. He is board chair for the Riverfield Country Day School and a member of the University of Tulsa College of Law Alumni Association. He received a BS degree in radio, TV and film, news and public affairs from Oklahoma State in 1976, which obviously assured that he would have to get an advanced degree after that to continue gainful employment. And he graduated from the University of Tulsa with a Juris Doctorate in 1983. Please welcome one of our own back to the University of Tulsa, David Tracy, and he's going to talk about collaborative law practice, a rising star in the realm of dispute resolution.
Well, it's an honor to be here. I have spoken previously to Professor Lemus's ADR class. I've spoken to Hugh Rainier's mediation class, and so this is not my first trip back to talk on this subject. I've spoken to the ADR club in past years, but I don't see a lot of familiar faces out there, so hopefully this will not be a repeat effort for many of you. Let me get a little feel for the audience here, because this is an interesting mix of people. How many people here are law students? Wow, okay. How many people here are attorneys? Interesting mix. And how many have had collaborative practice training? About 3 of you. Okay. Well, I'm not sure who to gear my presentation to. I think I'm going to pick the law students since we're at a law school. I think there'll be, I want the lawyers to jump in maybe and give us the benefit of your experience as we converse. Feel free to raise your hand and ask me a question anytime. I'll go to 120. We'll see how many slides I get through. And I know some of you have 130 classes. How many of you are here because you got a free lunch and you're making up a class? Okay. Well, there is no free lunch. You have to listen to the lectures, like the sermon after the soup. So this is the format I want to try to follow today. We'll see how far we get in 50 minutes. We'll start out by talking about what is collaborative practice, Mr. Fortney's original question. How does it work? When does collaborative practice work? Where does it work, and why does it work? Or why would you engage in collaborative practice? Those are all the old reporter questions I got from my undergraduate degree at OSU, so some of it still applies. The only reporters are always asking the question, who, what, when, where, why, and how. I didn't ask the who because the who in this case is you. So what is collaborative practice? I have done this presentation a dozen times if I've done it once, and this slide always changes because defining collaborative practice has been a struggle. And I always used to say collaborative practice is not in Black's Law Dictionary. But effective with the 9th edition, it actually is in Black's Law Dictionary. So I can start by telling you that according to Black's Law Dictionary, collaborative law is a dispute resolution method by which parties and their attorneys settle disputes using non-adversarial techniques to reach a binding agreement, with the understanding that if the parties cannot agree and choose to litigate instead, the attorneys involved in the negotiations will be disqualified from representing them any further. And that's an adequate definition of collaborative law. They've also defined collaborative divorce, which is interesting because collaborative practice has taken firm root in family law, but is struggling a bit to expand beyond the family law area. They define collaborative divorce as a divorce negotiated in a non-adversarial forum between spouses who, with or without a lawyer, are assisted as needed by a team of experts in law, mental health, and financial matters, such as taxes and real estate. I have a little disagreement with that definition because you cannot engage in collaborative practice without having collaborative lawyers on board, and not just one. You have to have at least two. But we'll talk about that later. Anyway, I'm glad to see collaborative practice in the dictionary, in Black's Law Dictionary. We're somebody now. We exist. It only took 25 years. So when I wrote this slide before I saw we were in Black's, because being an old guy, I have the 7th edition of Black's. The one key to a collaborative case is, if the case doesn't settle, I'm out. So settlement by agreement is intentionally pursued as the outcome of legal representation. Settlement by agreement means settlement only. I'm hired as settlement-only counsel. And the client needs to make an informed decision to hire me as settlement-only counsel. We'll talk a lot more about how to make an informed decision in that regard. And the other element I added to the definition of collaborative practice is that the parties enter into an agreement to participate in the process in good faith. You don't have a collaborative case unless you have a written participation agreement. Until everybody signs on the dotted line, it's not a collaborative case. Once everybody signs on the dotted line, you have a collaborative case, and the attorneys are precluded from litigating the case from that point forward. So disqualification from litigation and a written participation agreement that specifically states that are the essential elements of collaborative practice. And so let's talk a little bit about the framework for collaborative practice. Number one, I can't emphasize this enough, the disqualification requirement. If you're not disqualified, it's not a collaborative case. We'll talk about why that's important as the hour goes on. Also, the clients have to agree to delay or suspend litigation. Now, this is important because as an attorney, I can file a case, and if the parties decide that they want to turn it into a collaborative case with collaborative counsel on the other side, we can go into collaborative mode. So the clients can either start out with a collaborative matter, or you can start out with a litigated matter and switch it to collaborative. You just can't switch back with the same lawyers. So the lawyers are disqualified. The clients have to agree to defer or suspend litigation. And each client has to have their own attorney who will assist them in the negotiations. Now, discovery is part of the participation agreement is that the parties will agree to full disclosure as part of the written contract. Now, How do you get disclosures in litigation? Through discovery. Well, in collaborative practice, the discovery is voluntary. It's not done by court rules and motions and hearings on a compelling process. You have to agree in advance that it's going to be voluntary and it's going to be complete. How do you assure complete disclosure in a collaborative case? Well, in response, I would ask you, how do you assure complete disclosure in a litigated case? The idea of discovery in litigation is that the other person is not going to tell you anything you don't specifically ask. So we have the reverse situation in collaborative from litigation. We agree up front that everything's going to be disclosed in full. If you don't ask the right question in an interrogatory or in a deposition or by going on land and looking at documents and that sort of thing, you won't discover the information. And the job of the lawyer is to not disclose anything they don't have to. The job of the lawyer in the collaborative context is to disclose everything requested or everything that that lawyer thinks is relevant. And again, the client needs to understand that up front so they can make an informed decision that they want to participate in that process. And now it's a good opportunity to say that collaborative is not for everybody. If somebody comes into your office and says, I have $20,000 in a bank account in Mexico, the IRS doesn't know about it, Millie doesn't know about it, and I don't want her to know, not a good option for collaborative. Not a good option for you either. You need to say, you need another attorney, and by the way, don't tell them about the Mexican bank account. But be that as it may. Not every case is a good collaborative case. There has to be a basic level of trust between the parties that they will make full disclosure. If you don't have that basic level of trust, it's going to infect the process. When you have experts, we don't have battles of experts. In a litigation context, if we're involved in trying to value a business, say, and I hire expert A, I actually had this case once. My client said the business is worth minus $10,000, and the other side hired an expert that said the business is worth $300,000. So, we had a 4-day trial, and it doesn't matter what the outcome was. It was 4 days of semi-controlled chaos. In a collaborative case, if we have a question about the value of business, we hire one expert who is a neutral. And their job is to explain to the parties how a business is valued, how the particular facts of the party's case would be applied to these formulas and what the range of values might be. But a decision on the ultimate value of the business belongs to the clients, not to the hired guns. So we avoid the battle of experts by having neutral evaluations and active client participation in both the process and the outcome. And the goal, of course, is to reach a written agreement based on good faith negotiations on all aspects of your case. Now, collaborative practice has evolved over the last 25 years into a multidisciplinary process. Lawyers are used to hiring other professionals as resource persons, but the lawyers retain control over the process. In collaborative practice, we hire people from other disciplines as team members. So if we have a case involving custody of children and time sharing and money issues, we'll bring people on board as part of a team as opposed to simply being resource persons. And the reason we do that is because we don't always know what the most important element of a client's particular problem is. Practicing family law, which is this talk is going to focus on family law because that's basically what I practice and where collaborative practice is focused. It involves clients in the most stressful event of their lives, short of the death of a partner or the death of a spouse or immediate family member. And in some cases, it can be worse. It is actually the death of a relationship. And clients come to us in a very emotional state. And they have a legal problem, but they also have an emotional problem. And we don't always know during that first interview, during the course of our attorney-client relationship, which problem is going to be the bigger one. A lot of times we have clients who have emotional distress with legal consequences, and we have clients with legal problems that have emotional consequences. And the scales can tip during the course of a matter as to which is driving the bus. Okay? We all are familiar with the stages of grief. I don't know if I can recite them right now. Denial, anger, bargaining, acceptance, and I'm forgetting one, depression. You know, clients go through all of these. When a client comes to you, they're coming to you with one of the most significant problems in their lives. And in the course of dealing with that, we're not really, we can tell them about motion practice and petitions and preparing a case for trial and all that sort of thing, but we're really not equipped to manage the emotional dynamic. So what do? We tend to either sweep it under the rug or tell people to suck it up or pretend like it's not there, and that's how we manage it. But that's really not the most efficient way for the client to manage the problem. Pretend like it doesn't exist or ignore it. So we bring on team members. In the collaborative context, it usually involves mental health professionals who have a working familiarity with family systems and can identify the dynamics at work, the hot button issues. When people are getting a divorce, it's one of the problems you run across is that they have a history of not communicating very well. The coaches, the divorce coaches, can help us identify the hot button issues where people are not communicating well, and perhaps get these people on a road to effective co-parenting in the future, and resolve some of the issues that cause the divorce so they can have an effective two-parent family going forward. These are things that, we can put together a joint custody plan, we can put together a schedule for co-parenting, and we can get as anal as the parties want to about where you drop the kid off, where you pick the kid up, how you pay the support, and all these dynamics that can cause problems, who's in charge of haircuts. You get all sorts of goofy things that aren't an issue to you, but it turns out it's a big issue to the client. The coaches can put all those in perspective for the parties and send them forward in a much more productive manner. And it's also more efficient and gives you an opportunity to focus your time on what you're good at. So that's how the team process works. A lot of times you'll come into a divorce case and you'll have one spouse who's been in charge of the money for 23 years, and you have a spouse who can't balance a checkbook. So you need to get party B up to speed because they're going to be in charge of their own bills now. They're going to be in charge of managing their own money. And that's where a financial professional can come in. There aren't many people in this world who do cash flow projections on themselves. But that's one of the things you really need to do going forward if you're getting a divorce. So this team approach gives us an opportunity to apply the expertise involved directly to the problem the client is having in a much more effective and efficient manner. So that's how the team approach works. Okay, well, if I can't take the case to court, how do I manage it? Because I went to law school to learn how to prepare a lawsuit and prepare a case for trial and put on evidence and apply the rules of motion practice and pretrial process and post-judgment collection. I can't do any of that. If I'm the collaborative attorney, I don't have that option. So what kind of a framework do we use to get people from point A to point B? Well, the first thing we have to do is we have to get them to sign the participation agreement, because we don't have a collaborative case without it. And again, that takes us to the issue of informed consent. And we'll talk more about that later. But assuming we've signed a participation agreement and we have a collaborative case, the next thing we need to do is we need to find out just exactly what the goals of the parties are. How do we define a successful outcome in this case? It might be becoming single again without damaging the psyche of the children. It might be providing financial security for both parties going forward. It might be, let's see, give me some examples of some of my professionals here of what people's goals have been in real cases. Financial security is always a big one. Protecting the children, not damaging the children in the process, always a big one. And their goals, their concerns, their objectives might be different than your objectives in, if you were taking a case to court. They might come in and say, I want the house. So you prepare a motion that says, I need a temporary order, I want the house. Well, he wants it too. So, here we go. The judge is going to have to kick somebody out. Well, let's talk about, I want the house, but what is the concern, or what is the interest in keeping the house? It's providing security for the children, providing continuity for the children. So let's talk about bringing those goals up to a more macro level, instead of focusing on what I have to get from somebody else to obtain my goal. And what you find historically, in my experience, is as you develop these interests, concerns, and goals, you find the parties have interests, concerns, and goals in common, which is a great framework to start your conversation. It's like, well, you all are kind of afraid of the same things here. You all have the same concerns. So we'll address those. And we'll address those in a safe environment, a non-threatening environment. And it really takes a lot of the angst out of the room. Now, in any case, you have these immediate issues. For example, negotiating a separation. People have been walking on eggshells for months. Somebody finally pulls the trigger and says, I want a divorce. They end up in your office doing a collaborative case. It took 3 weeks to get to your first meeting. And everybody's ready to separate, but nobody wants to say who's going to leave. Okay, these are immediate concerns. Or let's say that the mortgage is 2 months behind. Or somebody's lost a job. Or the credit card bills are mounting. How do we take care of these? We all have these immediate concerns. And you put those on the agenda for the first meeting and say, okay, we can't solve these on a long-term basis because we don't have enough information. Well, what are we going to do to get ourselves to the next meeting? So you can take care of those immediate concerns and take away, again, a lot of the angst in the room by saying, okay, there are ways to address these things. We don't have to march down to the courthouse and have somebody in a black robe dictate how we're going to live our lives. We can do this ourselves. Last time I checked, there's no money tree at the courthouse. Okay, so once you've identified your interests, goals, and concerns, and you've put to rest some of the immediate problems that are at least going to get you to the next meeting without starting World War III, then you take a look at what information do we need to gather to address these interests, goals, and concerns. And there'll be a lot of the same information you would get in the discovery process. And what I have found is, by the first settlement conference that you have, you're halfway or more through the discovery process without anyone asking for anything. Because you've gathered bank statements, you've gathered credit reports, you've gathered copies of deeds, copies of car titles. You're 30 days into the process, and you've already saved thousands of dollars. And you're halfway to your goal of gathering the information you need. But then you figure out, well, we don't have everything we need. So here's a list of things we do need. Where do we get them? Who's going to be in charge of getting it? And then once you've gathered that information, everybody's done their homework, we're moving into the second and third and fourth session now. We take a look at the information, we take a look at where we're trying to get, and we talk about what are the ways to get there. And instead of saying, well, I want the house, no, I want the house, or I want the kids, no, I want the kids, we talk about what people's needs are, we talk about how to meet those needs, and we try to put at least 7 things on the table. Instead of saying, you move out, well, let's come up with 6 other options besides you move out. How about I move out? How about if we bird nest with the kids? How about if we put the house on the market? Just come up with, half a dozen or more scenarios for possible solutions. And some of them, as you examine those solutions, you'll find that they come to ridiculous conclusions. But as you explore those options, people come to realize that the options that are left are the options they have to work with. And there's nobody at the courthouse with a magic wand who's going to change your options for you. So let's work with what we have and figure out how we're going to get ourselves moving forward. And the lawyers are assisting them with the coaches and the financial professionals in making this progress. Then as you brainstorm these solutions, eventually the clients will self-select the option that's going to work best for them. For both of them, not just one of them. So you have a more durable agreement. You have an agreement that is possibly not one a judge would have used. And you have more buy-in because the clients came up with it. It's not being imposed on anyone. Okay, I want to emphasize a little bit more about the participation agreement and exactly what it does, because it's a very important document. It sets out the ground rules for the collaborative process, the full disclosure, the disqualification requirement, the expectations of the parties that they'll participate in good faith, that they have to be prepared to negotiate, that they're not going to get everything they want. It defines the engagement of the lawyers as a limited scope engagement, settlement-only counsel. And why do we do this in the participation agreement? Because it's all part of informed consent. By the time the parties sign the participation agreement, this should be the 3rd time that they have heard this information about the disqualification requirement, the fact that you can opt out of the collaborative process, and the other party can disqualify me from representing my client in court if they opt out of the process. The client needs to understand that. You talk about that at the initial consultation. You talk about it again at the pre-meeting before the first meeting, and then you talk about it again at the first meeting. Also, your attorney-client agreement has a special collaborative addendum that talks about the limited scope engagement. So by the time they commit to the collaborative process, they should have heard about this limited scope engagement and making an informed decision about how this works 3 times orally and twice in writing. So because it's vital that the client understand exactly what they're doing, hiring a collaborative attorney for a limited scope engagement. Okay, so how do these meetings work? How do these 4-way settlement conferences work? Sometimes they're 6-way settlement conferences. I've had a 7-way settlement conference with the financial professional, 2 coaches, 2 lawyers, and the clients. Well, you have to prepare for each meeting. When you go to trial, no one likes surprises at trial, right? 95% of what goes on at a trial you should expect, because you've done your discovery, you've done your trial preparation. You don't ask a question you don't know the answer to, unless someone throws you a curve, which they do every once in a while. In these settlement conferences, in collaborative cases, you should similarly have no surprises, because you've had a pre-meeting with the client and you've had a pre-meeting with the other team members. In the pre-meeting with the client, you're setting the agenda for the meeting, because if it's not on the agenda, you don't talk about it unless it's an emergency. If someone brings up something at a meeting, well, let's finish preparing for the meeting. So you set the agenda with the client, you talk to them about the hot button issues that might come up on their side of the table, the hot button issues that might come up on the other side of the table, and then you talk with your other team members about that. You call your collaborative counterpart and say, yeah, I talked to Debbie, and she's still hung up on the affair. We may have trouble getting past that. She may drop that bomb. How is Joe going to react to that? Well, Joe's ready to, fess up and apologize. And I've already talked to Debbie, and that would go a long way toward calming Debbie down, saying, all I need to hear is I'm sorry, and I'm ready to move on. Of course, she may move, the stages of grief don't come in order, and they don't, once you've hit it once, you can come back to it. So, she might get angry again. But that's what the coaches are for. So you have the pre-meeting, and then you have the actual meeting, where you follow the agenda. In the first collaborative four-way, the lawyers do most of the talking, because you're going over the participation agreement and emphasizing again these important items to make sure there's informed consent and you get feedback. It's important for the clients to hear from each other and in the presence of both lawyers that they're committed to the process. After the first meeting, you find the clients doing a lot of the talking because the lawyers have prepared them to do it and the coaches have prepared them to do it. So they're more involved in the meetings. And you're also prepared to handle, somebody drops the alimony bomb or the adultery bomb, and you're prepared to handle it because you've discussed it in advance. And then after the meeting, you follow up with the client. How did that meeting go for you? Did it go like you expected it to go? Did something not go like you expected? I need to know that too. Someone prepares minutes of every meeting. So you have the minutes of the prior meeting, the agenda for the next meeting. You debrief with your client, and you debrief with the other team members. How did the meeting go for the other team members? And also, I would add to this list that you set the date of the next meeting. Not scheduling these meetings on a regular basis is problematic. You end up like people do at the courthouse, waiting, 3 months for the next opportunity to do something. So never leave a meeting without having the next meeting set. So that's kind of that's sort of the framework for how we do things. We set goals, we address immediate needs, we gather information, we brainstorm possible options, and we come up with solutions using this meeting format. Now, one of the things I want you to notice is how much time are you spending with the client during this process? You see a lot more. You see a lot more of your client, and your client sees you working for them a lot more in the collaborative case than you do in litigation. In litigation, we go down to the courthouse and we're on a docket with 85 other cases, and you're waiting 2.5 hours to have 5 minutes of FaceTime with the judge. And your client's down there, maybe down there, reading a book or twiddling their thumbs, and you pop out every 45 minutes to do a little client management saying, we're still waiting for our chance to see His Honor. And then you might get 5 or 10 minutes of FaceTime, and then you come out and say, well, the judge says this. I don't like that. Well, that's what the judge said. We'll come back in a couple of months and spend another 2 hours wasting your time. And you don't have that in the collaborative case. You have meetings with the client where you're actually doing work on the client's case, preparing for meetings, having meetings, debriefing for meetings, working on homework. You spend a lot more time with the client, and when they know you're working their case, they're happier to pay their bill. FYI. Okay, so where does collaborative work? It works in any equity case. Yes, it is used primarily in family law. That's absolutely correct. But it'll work in any one of these areas where you have people in relationship. Yes, family law is the primary area. But think about wills and estates. Think about guardianships. Think about business partnerships, law firms breaking up. There's a dispute about how, what do you do with the ongoing contingent fee work? How are we going to divide those fees? Well, if you're having a dispute about it, let's sit down and talk about it instead of marching down to the courthouse and airing our dirty laundry for the rest of the bar to look at. I think this has a lot of potential for risk managers in medical malpractice cases. Because if you could get a neutral evaluation from an independent party and put the parties in a position where the doctor can say, I'm sorry for the outcome to the client, I think hospitals and physician liability groups could save a lot of money and preserve our relationships. But that's just me. So how did we get here from there? It all started back in 1989 with a lawyer in Minneapolis named Stu Webb, who is the acknowledged godfather of collaborative practice. He'd been practicing family law for the better part of 20 years in Minneapolis. He came back from the courthouse one day in 1989. And he had one of those cases where he got his client what she wanted, but the process of getting it was so ugly that he wasn't sure who won. And that happens a lot in domestic cases. And after you do that for 20 years, he finally said, there just has to be a better way. I am not doing this anymore. I am not putting my clients through this anymore. So he took some friends to lunch, and he said, let's do this settlement-only process. It's something he just invented. And in the process of sort of sorting through it, he wrote a letter to an associate justice of the Minnesota Supreme Court. And basically what he wrote was the Magna Carta of collaborative law. And he wrote this. He said, both you and I have experienced, I'm sure, those occasional times when, occurring usually by accident, in the course of attempting to negotiate a family law settlement, we find ourselves in a conference with the opposing counsel and perhaps the respective clients, where the dynamics were such that in a climate of positive energy, creative alternatives were presented. In that context, everyone contributed to a final settlement that satisfied all concerned, and everyone left the conference feeling high energy, good feelings, and satisfaction. Now, that happens on occasion in a traditional family law negotiation, or in the traditional, occasionally in mediation. A lot of times you're ending up with a good enough agreement, but sometimes you hit on all cylinders and the thing just rocks. And you can feel it. You can feel it in your gut. And so he's describing that. And if you get experience in negotiation, you'll feel that. Then he goes on to say, so my premise has been, why not create this settlement climate deliberately? I propose doing this by creating a context for settling family law matters by, where possible, removing the trial aspects from consideration initially. I would do this by creating a group of lawyers who would agree to take cases on a case-by-case basis for settlement only. The understanding would be that if it were determined at any time that the parties could not agree and settlement did not appear possible, if for other reasons adversarial court proceedings were likely to be required, the attorneys for both sides would withdraw from the case and the parties would retain new attorneys from there on to final resolution. And that, from that seed, Stu took 3 of his friends to lunch, and the collaborative movement was born. Now, similarly, in California, there was a group of mental health professionals who served as custody evaluators for Marin County divorce cases. And they were so frustrated by having to deal with lawyers who would cross-examine them and twist what they were saying about the parents and the children and distort things to the point where no judge could make an effective decision because they weren't getting good information. So basically, they were trying to come up with a system to get people divorced without getting lawyers involved. They were trying to cut the lawyers out because basically they were doing so much damage to family relationships in the process of getting people divorced that it was just harmful, and they recognized the harm. So they were trying to come up with a system where people would come to the mental health professionals, develop their parenting plans, and then they would go to mediation to do the financial stuff, and the lawyers would only come in on the back end to draw up the papers. Kind of, and again, another scope of limited engagement. So they were trying to cut the lawyers out of the process, and they were working with a gal named Pauline Tesler who heard about what Stu was doing in Minnesota. They put their brains together, and with a few shifts and stops and starts, the interdisciplinary collaborative divorce was born. In fact, at one point, the term collaborative divorce was trademarked by this group in California, but they've released that trademark now. So we had Stu in Minnesota doing this settlement-only, lawyer-only model. We had this group in California doing this interdisciplinary model, where the lawyers really weren't driving the show. They were kind of along for the ride, but they were involved. But they saw the benefit to this interest-based negotiation process and cutting out eliminating the possibility of creating an adversary situation and making their making themselves more effective in the process. And the process sort of grew organically from there. And now it's crossed North America, and the International Academy of Collaborative Professionals, as of last month, has over 4,200 members. They've trained over 22,000 lawyers around the world. Those 4,200 members represent 21 different countries around the globe, and this international movement has been created. Again, for some reason, it's just almost strictly in family law, and they keep trying to push the envelope and get it out here and there. And we'll see if it takes off. In 2006, because there were 3 states that had passed collaborative law statutes to recognize and validate collaborative law, but they were different statutes, the Uniform Laws Commission took up the task of drafting a Uniform Collaborative Law Act. And they spent 3 years working on that. In 2009, they put out the act. They revised it in 2010 to give states the option to create court rules, model court rules, instead of a model collaborative law act, because there were so many state court and local court systems that were developing their own independent rules about collaborative practice. The Uniform Collaborative Law Act was introduced in the Oklahoma legislature in 2009, passed the House 99-0, died in Senate committee. It has not been introduced this year because the Uniform Laws Committee decided there's been so much turnover in the legislature, and there's so many, they're all stressed out about budget issues, that they just limited themselves to 3 very straightforward uniform acts to promote this year. But we expect the Uniform Collaborative Law Act and or the model rules to be back next year. Okay. So let me tell you that by this point I first heard about collaborative practice in 1999 in Scottsdale, Arizona. And by this point in the presentation that was being made to me, I left. I said, this is not for me. I'm a litigator. And it had to sort of percolate in me for 2 years before I finally went back and said, this may make some sense. So it's okay if you're sitting back there being a little skeptical, saying this is not for me. Because it really does require you to, it's almost a schizophrenic existence for me to have litigated cases and collaborative cases, because you handle them so differently. You're using the same skill set. And we're not going to have time to do it, but I was going to try to list up here the skills you use to prepare a case for trial and try a case, and then talk about how you basically use that same set of skills in a collaborative case, but you just use them differently. And the way you use them differently is by engaging in this paradigm shift. Now, a paradigm is just a view of the way the world works. We all have paradigms. So you just have to shift your paradigm from litigation mode to interest-based mode. And the way you do that is you change your language, you change your body language, you change your tone, and you use different techniques to accomplish these goals. In litigation, your goal is to win the case. Your goal is to maximize your recovery and get a judgment against your adversary. In collaborative practice, you're trying to achieve goals and address concerns and meet interests, not just yours but the other side's. In litigation, you're focused on what someone did to you. In collaborative practice, you're focused on where we go from here. I could go on down the line. But and basically, this is in litigation. You're in the classic prisoner's dilemma. If you take a look at that graphic, they're shaking hands with the right, but they have the bat behind their back with the left. And whenever you retain the right, people ask me, well, how is this different from mediation? How is this different? I settle 95% of cases settle. 19 out of 20 cases settle. Okay? What I'm talking about is how you do it. And if I retain the right to go to court, you don't know what my left hand is holding. Even if I'm voluntarily giving you information, even if I am in mediation with you and appear to be in good faith, you don't know what I'm not disclosing. And you have to worry about what I'm not disclosing because you know what you're not disclosing. Because that's your job. In collaboration, in collaborative practice, we know that everybody has taken the bat from behind their back and they put it on the table. And the symbolism of doing that, what does that mean? Does that mean that you're vulnerable now? Back in 1999, when I first heard about this, that's what I felt like. I said, these people are trying to tell me that I need to be vulnerable, to make my client vulnerable. But in fact, once I made the paradigm shift, it's exactly the opposite. Instead of being vulnerable, I put myself in a position where I don't have to be defensive. I don't have to defend myself. And the other side doesn't have to defend itself, which is actually an empowering move, not a position of vulnerability. And once you make that shift in your head, you realize that, oh, this is in fact a powerful tool. You're not in a position of weakness. You're in a position of being non-defensive, which gives you full range to assert what you're after. But in an atmosphere of respect, in an environment where you're safe to do that, and you're safe to actively listen to the other side. That's the paradigm shift that distinguishes collaborative practice from mediation or traditional settlement negotiations or litigation or arbitration. Thank you. And it's also unique in that it's entirely voluntary. A court can't order you to collaborate. You can be ordered to mediation. You may have signed an adhesion contract for arbitration, which may be binding or non-binding. But you can't be ordered to collaborative practice. And I'm running out of time here to talk about the role of the attorney in the collaborative case and the role of the coach in the collaborative case. It's very interesting to work with other professions as a team for the benefit of your client. And it's very rewarding because you can always say, you know what? That's a job for the coaches. Let's turn that over to the coaches. It takes a lot of pressure off of it. You can focus on what you do well. And the coaches can also serve a role, this is a very important role, of child specialist. Think of, in the family law case, you have a guardian ad litem. What does the guardian ad litem do? They're an arm of the court. Their job is to investigate the home environment for the child and to make recommendations to the court. That's not what a child specialist does. In a collaborative case, the child specialist gives the child a voice without giving them control. So it gives the parents information they need to make good decisions about the future of their children, and it gives the children a safe place to get information about what's going on in their lives and what their options are. So it's a very different role from the guardian ad litem role, and a very useful role for the children and the parents. And the financial specialist, we'll have to talk about that later. And I'm sorry I don't have more time to talk about ethics, but I will tell you the preamble to the Code of Professional Responsibility talks about the lawyer's role as advocate, as advisor, as evaluator, and as negotiator. And none of those roles are superior to the others. So we all think about, taking up our spear and portraying our client as a victim and taking on the persecutor and rescuing our client. And that is something that you can do in litigation. But in collaboration, you're still zealously representing your client to provide them with legal information and to assist them in the negotiations and to make sure that they're doing things with proper information. Client screening, again, as I said, this is not for everybody. You particularly have to watch out for domestic violence issues. We all need to be screening our clients for possible domestic violence. The last thing you want to do is to put an abuser, an abused victim in the room with the abuser and expect them to be fully empowered to negotiate. Now, I say that, and I know I'm running a little long. I really have to shut this off, but this is very important. When you're screening your client, think about what protection they can get in court, or what they can get in court versus what they can get in the collaborative process. And if you have a team working with someone who's not a chronic victim of domestic abuse, who is so beaten down, their self-esteem is so far gone that there's just no way to rehabilitate them so they can negotiate effectively, yeah, that's not a collaborative case. But it may be possible to get someone who is a victim of domestic violence more relief in the collaborative context than in a litigation down at the courthouse. So you have to be very careful about that. It's not cut and dry. The rules of your professional conduct are not superseded by collaborative practice. You still have to conform to those rules. That applies to each profession. If you want more information, you can go to this website, which is the website of the Oklahoma Academy of Collaborative Professionals, yourdivorcedchoice.com. The International Academy is www.collaborativepractice.com. A lot of useful information in those areas. And this is the paradigm I want to leave you with. In litigation, it's a tug of war where everybody's pulling against each other, and there's a big pile of mud in the middle, and everybody gets muddy, and one side wins. In collaborative practice, you're all trying to get to the same goal. You're working in the same direction. So those are the paradigms I want to leave you with. And I'll also leave you with this quote from a university, a Pepperdine University professor. He said, "Peace is not the absence of conflict. It is that state when we can resolve conflict efficiently and effectively." So, go in peace, and thank you for your time.